Speakers today are Margherita Cornaglia, Nick Toms and Paras Gorasia. Margherita will be giving us a legislative overview and will be speaking about commencement of consultation. Nick will be speaking about representation and what consultation entails. And Paras will be speaking about special circumstances and protective awards. Now, you will have seen that your microphone is on mute, so please don't be alarmed by that. It's just to stop any interference throughout the webinar. And there will be an opportunity to ask questions throughout, which we will address at the end. So please do utilise the question tab at the bottom of your screen. So without further ado, I'm going to pass this over to Margherita, who is our first speaker of the day.
Welcome everyone, and thank you for attending this afternoon. I do hope you will find this webinar useful. As Callum mentioned, I will give a brief legislative overview of the collective redundancy provisions and speak about commencing consultation, and then we'll pass over to Paras and Nick to continue. So the main obligation to consult and inform with the workforce about proposed redundancies is provided for in the Trade Union and Labour Relations Act 1992 in section 188. The scope of that obligation is important and is as set out in the slide. Essentially, an employer proposing to dismiss 20 or more establishment within a period of 90 days will be caught by section 188. And the obligation therein is to consult representatives of any employees who may be affected. The provision recognizes that there are employees whose jobs may not be threatened by redundancy, but who are nonetheless directly or indirectly affected by the proposals. And these employees too have to be included in the consultation. Just briefly, a note about definitions. The definitions of employee and employer are set out in section 295 of the Act. References to statutory sections in the slides refer to the Trade Union and Labour Relations Act unless specified otherwise. And the definitions of employee and employer are as set out in the slides. A few important points to keep in mind. Fixed-term employees are excluded from the duty to consult unless prior to the expiry of the fixed term. And overseas employees must be included in consultation as well. In terms of employer, it's important to keep in mind that the Act relates to employers who are actually in control of the employees in question, so those who actually employ the employee. So for instance, where a decision to make employees redundant is taken by a company controlling the employer, the obligation to consult always lies with the subsidiary. There is one exception in relation to this, which has to do with transfers of undertakings. So essentially, where 2P applies, the transferee employer is to consult with affected employees about redundancy before the transfer takes place, even though at that stage the employees are still employed by the transferor, and that is set out in section 198A and B. Moving then to the definition of dismissal and redundancy. The definition of dismissal is set out in the Rights Act. There are two broad circumstances that amount to dismissals. The first is where an employee's contract of employment is terminated by the employer with or without notice. And the second refers to constructive dismissal, so where an employee resigns because of a repudiatory breach of contract by the employer. Both those circumstances are caught by the definition of a dismissal. A redeployment may amount to a dismissal where it is not within the terms of the original contract, so where the employer withdraws the existing contract, or where the employer departs so substantially from it that it amounts to a withdrawal. Again, important to keep in mind that section 282 subsection 2 provides that the expiry of a limited term contract does not amount as a dismissal for the purposes of a redundancy consultation unless the contract is terminated by reason of redundancy. When in terms of voluntary redundancies, ultimately it is a question of fact for the tribunal to decide whether there has been a consensual termination of employment, in which case there will not be a proposal to dismiss, or whether there has been, whether the employee has be made redundant, so to be dismissed, in which case the employee must be included in the calculation under section 188 and must be included within the employer's consultation. Redundancy itself is defined in section 195. It's important to note that the definition in the Trade Union and Labour Relations Act is much broader than that in the Employment Rights Act, which covers individual redundancy. In the Trade Union and Labour Relations Act, references to dismissal as redundant are considered to be references to dismissal for any reason which is not related to the individual concerned. So for instance, in University of Stirling, the Supreme Court held that the dismissal of an employee on a fixed term contract at the point when the fixed term expired was not for a reason related to the employee, and so was for a reason relating to redundancy. Now that has been overturned by section 282, which was just mentioned. However, the Supreme Court endorsed an EAT test, which is set out in the slide and which continues to be valid. But generally, the point is that the definition of redundancy under the Trade Unions and Labour Relations Act is much broader than that under the ERA. Moving then to the timetable for consultation. Section 188(1)A provides for the statutory minima periods for which consultation must be undertaken. Where there are 99 employees, the employer must consult for a minimum of 30 days, and when there are 100 or more employees, the statutory minima is 45 days. What does this mean? This does not mean that an employer must consult for the entirety of the 30 or the 45 days. Consultation can be less for that minimum period, so long as it takes place when proposals are at a formative stage and so long as representatives are given sufficient time to meaningfully contribute to the consultation. However, an employer must not bring forward the date of dismissal. So the dismissals themselves must happen once the statutory minimum period have expired. So even if consultation lasts less than the statutory minimum, the dismissals themselves cannot take place before the statutory minimum period have expired. In addition, section 188(1)A provides that consultation must begin in good time. This is a less stringent test than the previous statutory provision, the previous version of section 188, which provided that consultation had to begin at the earliest opportunity. This has now been amended, and it was a deliberate move by the government to reduce the obligation on employers to the bare minimum required by their European directive, which the Trade Union and Labour Relations Act implements in domestic law. Whether consultation has begun in good time is a question of fact for the tribunal, which takes into consideration a number of factors. There are a couple of cases that give some pointers as to what in good time might mean. So in Amicus and Nissan Motors, it was held that in good time means no more or no less than time sufficient for fair consultation to take place, working back from the date of the first dismissal. So the employer should ensure that they begin consultation early enough to enable meaningful consultation to take place. And Nick will address what meaningful consultation entails in just a moment. But generally, it's quite a broad and flexible test that is to be applied depending on the facts of the specific case. In complex cases, it may mean allowing more than the statutory minimum period. In keeping kids, the court ruled that in good time is synonymous to promptly. So again, quite a flexible concept. Moving then to what proposing to dismiss means. It's important to address this phrase because it's the trigger for the obligation to consult. When the employer proposes collective redundancies, the obligation is triggered. There is a broad conflict with European law, which provides that the obligation is triggered once the employer is contemplating collective redundancies. So in the M&F case side, it was held that the Trade Union Relations Act was inconsistent with the directive because of this difference between proposing and contemplating. And indeed, in Junk and Kuhnel, the European Court ruled that the obligation arises before the employer has set its mind on dismissals, whereas in UK coal mining, it was held that the domestic test is slightly different, and that the obligation does not arise when closure is mooted as a mere possibility, but only when it is fixed as a clear, albeit provisional, intention. The ECJ revisited this question in Akhavan and held that the obligation arises only once a strategic and commercial decision compelling the employer to contemplate or plan for redundancies is made. So despite this back and forth between the domestic and the European Court, ultimately following the amendment to section 188(1)(a), such that consultation must begin in good time rather than at the earliest opportunity, the question of what proposing to dismiss means has become less significant. Now that an employer is only obliged to consult in good time rather than at the earliest opportunity or immediately, the need to pinpoint the precise moment at which the duty to consult arises is diminished. And that is because deciding whether consultation happened in good time is likely to involve focusing on the date of dismissal and looking at what happened until that date, rather than pinpointing the date when the obligation arises. Amicus and Nissan Motors recognized this and held that so long as consultation does not begin so late that proposals for dismiss have effectively been cast in stone, there should be no grounds for complaint to an employment tribunal that the process did not begin in good time, or that the process only began some time after the possibility of mass redundancies was first mooted. So again, the important thing is that consultation is undertaken when proposals are in a formative stage, such that representatives are given the opportunity to contribute meaningfully. A brief note on ascertaining the number of redundancies as provided for in section 188 subsection 3. Multiple redundancies are treated in a slightly different way. So where the employer has begun consulting in respect of a first group of employees proposed for dismissal, and then proposes to dismiss a second group of employees, the two groups cannot be aggregated when determining the number of redundancies for the purposes of section 188. The situation is different where the employer proposes to dismiss a total number of employees but decides to stagger those dismissals. In that case, the dismissals are aggregated and are counted together when it comes to determining the total number of dismissals for the purpose of identifying the obligation under section 188 and the number of redundancies that are proposed at a single establishment. Moving then to the meaning of establishment. This phrase is particularly important because the obligation to consult arises when 20 or more redundancies are proposed at one establishment. So defining what an establishment is important to determine how many redundancies are contemplated and whether the obligation in section 188 does or does not kick in. If there's more than 20 redundancies proposed at that one establishment, the obligation does kick in. If there's fewer than 20, it does not. In Rockfon, it was held that the term establishment is a term of community law and is defined as the unit to which the employees are assigned to carry out their duties. Rockfon was endorsed in Atinaiki, which confirmed a number of things in relation to the definition of establishment. First of all, the term is to be defined broadly. Second, the term establishment is an establishment is a distinct entity with a degree of performance and stability assigned to perform one or more given tasks. It has a workforce of its own, technical means, and a certain organizational structure, but it need not have any legal, economic, financial, administrative, or technological autonomy. Similarly, it need not be endowed with the management of its own. And in C Unlimited, it was held that that an establishment need not be a physical unit. it can be an organizational too. A few examples from the case law, looking at what a unit to which an employee is assigned means. So in Mills and Allen, a number of redundancies were directed at the Manchester Direct Sales Department of Mills and Allen Limited. The EAT held that the tribunal was entitled to find that the department itself employees such that the obligation to consult did arise. In it was held that a school is capable of being a unit, and whether it is the teacher's establishment depends on the teacher is assigned to that school. The tribunal had relied on the fact that the school was controlled by the council's education and leisure service to find that it wasn't the teacher's establishment. The EAT held that that was misplaced. One need not look at the controlling service, but at the establishment itself. Ultimately, it's a question of fact, and it's not a question that depends on the employee's contractual position, nor does it depend on who controls the unit in question. In Turney, Reimer and Sainsbury's, an employee worked for Sainsbury as a community and health advisor. Advisors were given a supermarket as a home store. It was held that the advisors were organized as a national team, and so that they were a distinct entity within Sainsbury's Limited. So it was ultimately held that the employer had to consult over the redundancy of 34 such advisors. An interesting set of cases concerns retail chains in liquidation, and that's the Woolworths case and the Little and Bluebird case in Northern Ireland, the latter of which was a Northern Irish case. In Woolworths itself, there was a liquidation of a set of retail chains, and the employment tribunal had held that each of the individual store was an establishment in itself, such that there was no duty to consult in relation to fewer than 20 employees. The Employment Appeals Tribunal overturned that decision, holding that Section 188 was incompatible with the directive, and it held that to cure such an incompatibility and in accordance with the principle of under European law, the words "at one establishment" had to be deleted from Section 188. The case reached the Court of Appeal, who submitted to the Court of Justice. The European Court of Justice confirmed the Rockfund definition, but it did not conclusively determine that each individual store should be considered as a separate establishment. However, its judgment did clearly suggest that this was a permissible approach. When the case returned to the Court of Appeal allowed the appeal by consent and overturned the Employment Appeal Tribunal's decision. So the words "at one establishment" are now firmly set in Section 188. In Little and Bluebird was decided 2 weeks after the ECJ's decision in Woolworth. Again, the ECJ in Little held that the directive does not require every establishment, so every single store, to be aggregated. And the Industrial Tribunal in Northern Ireland, applying that decision, held that every individual store was per se an establishment. So the two cases suggest that when large redundancies affecting retail chains occur, courts will be likely to can be establishments per se, such that stores with fewer than 20 employees will not be caught by the obligation to consult. Moving then to ending consultation and dismissal notices. First of all, Section 193 places a statutory obligation on employers to notify the Secretary of State of proposed redundancies wherever 20 or more redundancies are contemplated. Section 194 specifies that a failure to notify is a criminal offence. Notice must be given appropriate representatives. Dismissal notices. In Jung and Kuno, the ECJ held that an employer is not entitled to give notice of termination until after the conclusion of the consultation procedure and after notification to the competent public authorities. What this means is that running the consultation period alongside the notice period is incompatible with the directive. And indeed, the ACAS guidance provides that redundancy notices must not be issued until collective and individual consultation is completed. However, the notices may be given prior to the expiry of the statutory minimum period, so long as consultation is genuinely complete, and so long as the dismissals themselves, as mentioned earlier, do not take place until after the expiry of the statutory minimum, either 30 days or 45 days. Ending consultation. So in Vauxhall Motors, it was held that so long as consultation is meaningful, there should be no grounds for finding a breach of Section 188 simply because dismissals take effect sometime after the procedure was instituted. So on the facts of Vauxhall, in January 2003, the employer notified the Secretary of State via the HR1 form. The notification was followed by further proposals and extensions while consulting with the employee's appropriate representatives, and dismissals were finally effected in November 2004. It was held that there had been a seamless and meaningful consultation from January 2003 up until the date of the first dismissals. So the elastic of Section 188 had not been broken, and Section 188 had been complied with, despite the fact that consultation took place over an extended period of time. Finally, moving to complaints, appropriate representatives will be dealt with in more detail by Nick. I will just mention them here in relation to who has standing to bring complaints. Complaints for breach of Section 188 are provided for under Section 189 of the Act. Essentially, where an employment tribunal finds a breach proven, it must make a declaration to that effect, and it may make a protective award, which Paris will deal with in due course. The important thing to keep in mind for the time being is that Section 1891 makes very detailed provision for who is allowed or entitled to bring a complaint. And the entire section has been copied on the site following the webinar. But the important point is that unless the appropriate person brings the complaint, it will be held to be inadmissible, as was illustrated in Mercy and Northgate, where it was held that an employee did not have standing to bring a complaint for a failure relating to employee representatives falling within Section 1891B. The proper approach there should have been for the employee to raise the complaint with his or her representative, who would then have brought a claim under Section 189. Similarly, Hartford illustrates that the standing provisions have an effect on protective awards. So employees who missed out under the terms of a protective award because they weren't parties to the claim can apply to the employment tribunal under Rule 2R to be joined out of time the case because they have an interest in the outcome of the to rectify the scope of the original award. So not an ideal procedural situation to be in, but there is an opportunity to apply under Rule 10 to amend the scope of the protective award where an employee has been excluded from the proceedings in the first place. Finally, the next slide is just a brief statutory roadmap of the next topics. And with that in mind, I will hand over to with appropriate representation for who will deal with representation for consultation and what consultation entails. Thank you for listening.
Hello, here we are. COVID-19 has brought us various new experiences, of which this is one. A webinar. We can't see who's actually out there, And of course, doing it from home, where we have 3 children homeschooling and various other activities going on as well. So hopefully we won't be interrupted, and we shall do our best. The starting point, from my point, is of course looking at the issue of consultation. Of course, it's somewhat sad we're dealing with this subject at the moment, collective redundancies and redundancy. No doubt another factor which COVID has introduced, and for employment practitioners will become more and more, sadly, a feature, I suspect, of our legal casework in the coming months and year, as the implications economically of the COVID-19 virus disaster hit home, with one suspects will be a large numbers of job losses, if those haven't obviously already started. In fact, especially once the furlough scheme comes to an end. Now, consultation is an important part of the redundancy process. As we'll see in a second, it forms a central part of the statutory procedure, which applies to collective redundancies. And it's also highly relevant to redundancy selections where it doesn't apply. So that even if you only have 1 employee being made redundant, there is likely still to be a duty to consult in that situation. Indeed, one of the earliest cases I recall doing was a redundancy case, unfair dismissal, and that involved 1 person in a very small business being made redundant. And in fact, the one point we won on was consultation. Sadly, when she gave evidence as to would it have made any difference, she responded, well, probably not. And I couldn't think of anything else to say. So our compensation was limited to the 1 month the tribunal assessed it would have taken to complete the consultation process had the employer done it properly. But it underlines that it is important, even in those small situations, that there is consultation by the employer. And so let's move on. Of course, it has 2 elements, and we're primarily in the statutory scheme focusing on the collective element. That's, even where it isn't a statutory scheme case, the collective element, i.e. consulting with the union, in all likelihood, is important still, but clearly in the statutory scheme, it's particularly important. And basically, there are effectively 3 options in terms of who is to be consulted with when you look at the statutory scheme. Where there is an independent trade union, which is recognised by the employer as the bargaining agent for employees of a relevant description, then the appropriate representatives for consultation will be those nominated by the union or accredited by the union. So what that basically means is that the employees of a relevant description are those who are either facing possible dismissal or who may be affected by measures flowing from dismissals related to the dismissals. And as long as the union is recognised for some purposes, it doesn't have to be recognised for the purpose of redundancy selection, as long as it's recognised for some purposes by that employer, and at least they've got at least 1 member in the group of people involved in the redundancy process, then the union is likely to be the appropriate representatives of it, are likely to be those accredited by the union. So as you can see there, the fact is that all the employees affected do not need to be members of the union for the union to be the person or the organisation that appoints the appropriate representatives. And you can flick on there, Callum. Where there is not a union, then basically, somewhat surprisingly you may feel, given it's the employees ultimately who are the ones in the process, it's the employer who has the choice as to which option they prefer of the remaining 2. And those options are either, sorry, nothing that relates to me. There's a message flicked up there. That's nothing to do with me. Those options are either they can consult employees who have been elected by the employees for some other purpose, and the obvious examples there would be things like works councils, staff consultation committees, and that sort of thing. They can choose to consult that sort of employee representative, or alternatively, they can choose to consult representatives specially elected for the purpose of the redundancy consultation. So that is a choice, somewhat surprisingly, nevertheless, that's what the statutory scheme provides of the employer. And if the employee chooses that last option, i.e. to elect representatives for the purpose of a redundancy consultation, then there is a very detailed procedure which they are to follow. I've not put it in these notes. We see lots of points in going through that in detail, but if that is something you're asked to advise on, then you need look no further than section 188A of the Changing in Labour Relations Consolidation 92 Act to find the detailed steps the employer is expected to take. You can skip on. Whichever way they decide or however the representatives are chosen, just briefly to note that the employer must give them sufficient facilities, accommodation, other facilities, and also afford them access to the affected employees. They are protected against detriment for acting or proposing to act as a representative. That is, of course, the claim of detriment under the Employment Rights Act. As you'll be aware, if someone is subject to a detriment for any reason, including this reason, then the compensation is both financial and potentially also injury to feelings. And of course, they're also protected against the being dismissed for this purpose. Although this is not one of the dismissals where the cap is removed, consequently, even if it is an automatic unfair dismissal, they are still going to get hit by the statutory cap. And no, representatives may also be entitled to paid time off work to enable them to discharge their functions or to undergo training in order to discharge their functions. Do you want to skip on, Callum, please? Right, what should consultation be about? Some of this has been covered just now, so I'm not going to repeat what was just said, other than just to note consultation is supposed to be about the proposed dismissals or any measures taken in connection with the proposed dismissals. And the phrase any measures, more recently, I mean, it's a while since I've done a collective redundancy case, but certainly I've done 2P cases more recently. And of course, those of you who've covered those sorts of cases will know that the concept of measure is a word which has been given a wide definition by the Employment Appeal Tribunal as to any act, step or arrangement in the IPCS and Secretary of State Defence case in 1987. Do you want to move on, Callum? Callum? Move on. Oh yeah, sorry, consultation must be good. You can skip over this, this has already been covered. You can skip over this, this has also already been covered. And yeah, just this wasn't fully covered. In terms of the duration of a consultation, the Act is silent on that. But that case there, you can see amicus and Nissan Motor Manufacturing Limited. You can see there that the EAT there set out various factors which are relevant in terms of deciding basically both the concept of good time and also the fair duration of a consultation. And that's going to include things like number of staff involved, the complexity of the proposals, what is a reasonable time for the unions to be able to respond to the proposals and make counter suggestions whilst they're at a formative stage, the outcome envisaged, the number of subjects to be discussed in the consultation, the number of meetings required, changes to the proposals which take place may also, as the process unfolds, may also mean that the duration needs to be extended. Do you want to move on, Callum? It's the employer that initiates the consultation, as we've seen, they have to do it in good time. And what they must do is provide information. All the actual Collective Redundancies Directive refers to the employer being required to provide all relevant information. TULRA is a little bit more prescriptive. It doesn't say all relevant information. It has 9 categories of information which the employer is expected to provide, and they must provide this information. They can't rely, for example, on the fact that they think that the union reps or whichever reps are representing the employees know this stuff already. They can't assume anything. They have to provide this information, and you can see what that is set out. That is just simply lifted from section 1884. So I'm not going to go through it line by line. You know, if you have a case on information, then that's where to look, and that's the list which you'll see in section 1884. Do you want to move on, Callum? But don't know, the information, so I've just said already, must provide each and every item of the required information. It needs to be provided in writing, and it must be provided to the appropriate representatives or the trade union, which of course could well be the trade union, or the either elected employees for the purpose of the consultation, or those who are from a works council or whatever. It must be as fully provided as possible. Basic information is not enough. The intention of the directive is that the representatives should have the relevant information, and ideally that should be provided, of course, at the start of the consultation process, because obviously that's what you're going to be talking about. However, note there is a proactive and ongoing continuing duty to provide information as it becomes available. Move on, Callum. Right, the consultation is supposed to consider basically ways of avoiding the dismissals, reducing the number to be dismissed, or mitigating the consequences of the dismissals. And note, the legislation says it should be undertaken by the employer with a view to reaching an agreement. And we'll come on to look at that briefly. Does that mean there's a wider duty, really, not just to consult? Because ultimately, a duty to consult ultimately doesn't really mean very much. Yes, here we are, here's all the information. Thank you very much for your interesting views. Of course, they're not allowed to say this, and of course wouldn't have the evidence ready to demonstrate that in fact they had already made up their minds as to what they were going to do. And this is in fact purely an exercise that they're obliged to conduct because of this annoying legislation. But it should be taken with a view to discussing and reaching agreement with the union. Note, the ECJ goes even further in that case I've set up there, and not just to avoid redundancies or reduce the numbers, but also to mitigate the consequences by recourse to accompanying social measures, aid, etc., for redeploying or retraining workers made redundant. Do you want to move on, Callum? No, go back a page. There we are. As you'll see from this, the subject matter of consultation does not go as far as to cover the economic reasons that have led to the need for redundancies. This is an interesting question. The issue isn't wholly settled, as you can see from the last bullet point, and it may well be, particularly for those who represent claimants, as indeed I mainly do myself, that this is something that needs to be explored further. Because at the moment, the general position of UK law, and indeed the ECJ, is that what you can't consult about are economic decisions taken by the employer in terms of the managing of their business that have led to the redundancy situation. And of course, in unfair dismissal, you will all be aware in unfair dismissal law that in an employment tribunal, when you're looking at individual unfair dismissal, unfair selection for redundancy cases, one of the areas you're not allowed by and large to tread is that if the employer has done sufficient evidence-wise to show that there was a redundancy situation, you can't look into the business decisions and say, well, look, that was a completely mad business decision, and consequently, that's why we're ending up here, and that's what the tribunal should be investigating. You can't go there. And it appears really that that's what this is saying in terms of collective decisions as well, in terms of the current state of case law. So the employer may decide to take certain steps with their business, for example, merging, or not merging, discontinuing a production line, all of which may lead to a redundancy situation. And although ultimately that's what has caused the redundancies and that's what's gone wrong, that is off limits. What you can consult about is that once that strategic or commercial decision is taken, the consequences of that decision in terms of redundancies, mitigating and minimizing job losses of the decision that has been taken. That's the law. In my opinion, it's extremely questionable whether that is right, certainly from any sort of moral point of view. Obviously, as lawyers, we don't deal in morals, but as I say, the legislation, it's not wholly settled. Certainly, the UK mining case suggested that where the whole workplace is closing, that a wider consultation may be appropriate as to what's led to that. And it may be something that we should explore from the point of view of claimants, certainly, if there are large-scale collective redundancies, and we should perhaps look to see whether we can and should, in the 21st century, where the employees have as big a stake in a business, certainly, as anybody else, they should be able to also help, as part of the process, examine what's led to that disastrous situation where they're all facing, or many are facing, losing their jobs. Okay, we'll move on. Okay, this is another, I think, a very important point. Consultation should be meaningful. And I sort of hinted at the sort of consultation you sometimes get earlier. Consultation, both within the statutory procedure and the non-statutory procedure. So that means basically where you're looking at, for example, an unfair selection, unfair dismissal case, the consultation should be meaningful. And I've always found personally this this extraction in the ex parte Price case very helpful, Lord Justice Glidewell, where he summarised really what is a meaningful consultation. It's where proposals are at a formative stage, based on adequate information to which to respond, adequate time, and for conscientious consideration of any response to the consultation by a decision maker. And I've always found that that's extremely helpful sort of starting block for what is meant by a meaningful consultation. Do you want to move on now? In my experience, HR professionals often do approach consultation as a tick box exercise. They will ensure that, you know, they'll have read their noddy book of employment law practice, and they will have said, well, look, we need to have various meetings with various people. If, you know, there's over 20, that might mean we have to deal with statutory procedure, and we'll have these various meetings, but in reality, nothing much is going to change. It's a purely sham exercise, going through the motions, where they are not, you know, the reality is that whatever the poor person or union says in the consultation procedure is not going to really change anything, because the decision has already been taken. Now, that is not a consultation, and certainly that's one of the things that employment lawyers need to carefully examine when you're looking at these cases. Has there actually been proper, genuine consultation, or was it a tick box exercise? Because clearly the employer is not complying with their obligations if their mind is already made up at the start of the process as to what they're going to do. So in reality, any representations are falling on deaf ears. You want to move on? And the sort of evidence that you might want to examine or indeed prepare is looking at, for example, where there is collective consultation, where representations were made by the unions, where did it go? Who took any note of what was actually said? Is there any evidence that board meetings or other meetings of decision makers actually considered and reflected on what representations were made by the union or by the representatives? That's the sort of thing which I personally always like to look for. Is there any evidence of pre-existing or pre-taken decisions? So it's always obviously a little suspicious, as indeed it does happen even still these days, that you turn up to your redundancy consultation meeting and at the end of it you're handed your letter of dismissal. And you may think, well, maybe that was typed in advance. And therefore there hasn't been proper consultation, and that's the sort of evidence. And look at the timetable closely of when representations are made and when decisions are taken, to see if there's any evidence which suggests, in fact, that the consultation was not a genuine, meaningful consultation, but a sham exercise. Do you want to move on, Callum? Let's say, arguably, the duty to consult does go a bit further. Is it a duty to negotiate? Although, really, even if it is, does that make any difference? Because ultimately, whether it's consultation or indeed negotiation that's taking place, ultimately, under the current procedures, the employer still has the final say. And even if they have very diligently and genuinely listened to what's being said, if they ultimately make the decision as to what will happen, which redundancies will be made, what other steps and measures will be put in place in regards to those who either who aren't being made redundant, retrained, or are being made redundant in terms of retraining, alternative employments, and so on. That ultimately is still the employer's decision. So unless ultimately, as the ECJ has certainly suggested, it's not just about negotiation, it's about reaching agreement, because if it's about reaching agreement, that clearly creates a far different power situation than it is if it's just simply about listening to what the unions have to say or the representatives have to say, but ultimately the employer takes the decision. You want to move on? I know this is a legal webinar, but I did feel it important, particularly again, if you're advising claimants, that we obviously as lawyers focus on the law and legal claims and outcomes, quite rightly, that's our job. But I think our job does involve as well looking at other options and discussing them with our clients, and recognising, with our clients that the law is a limited tool in the industrial context, and ultimately you can't legally stop redundancies. You can try and mitigate them. You can try and do your best to get other work for those employees and minimise the impact on those who are staying as much as possible. But ultimately, you can't stop it. However, there may be other ways, which I have just flagged up there, which I certainly those advising claimants should consider discussing, at least raising. It's obviously up to the union or as to what they do. It's going to come down to issues such as what's the feeling amongst the membership, what's the density of union membership, but things like industrial action, large-scale redundancies aren't something which we've really experienced for quite some time now, apart from the odd industry, the odd large retailer going to the wall. But certainly in the 60s and the 70s, there were quite a wide range of imaginative means adopted by unions and employees and workers in resisting closures of their workplaces. Things like occupations, work-ins, sit-ins were quite regular and common. Perhaps one of the most well-known was the Upper Clyde shipbuilders, but there were many others. Sadly, I'm old enough almost to remember from experience, personal experience. But that is something that hasn't featured on the political agenda more recently. But political campaigns, alternative means of ownership, all of that is, I think, probably relevant to be raised. Although clearly, to the extent as lawyers we can advise on it is of course limited. Do you want to move on, Callum? Briefly, someone's just flagged up a question. Handily, it was already in this this presentation. Very briefly, the statutory procedure, as we've seen, does not apply to every redundancy situation. However, even where it doesn't, consultation is an important element of the redundancy process, as I said at the start. And indeed, if a very useful case for any of you who do redundancy unfair dismissal claims is the Mugford and Midland Bank case. It's an older case, 1997, but oldies and goldies, the law hasn't significantly changed. And it has held that the failure to consult with either the union or the individual would normally make the dismissal was unfair. And I've just set out the matters which in an individual redundancy are relevant. That will include, the employee being asked what are any options have you got to suggest how we could avoid this. Individual employees certainly may not be have that much input on the selection criteria, but certainly one thing they will be interested in is their own scoring. And of many employers, I don't think there really is an obligation necessarily to provide the scores of other people so they can consider, overall whether they've been marked badly or unfairly. But there certainly, I think, is an obligation. I did a case years ago under the old statutory procedure, Alexander and Bridgend Enterprises, which probably isn't good law anymore because that procedure's gone. But what it established was at least for the point of view of that statutory scheme, the employer would not comply with the minimal requirements of that scheme if they didn't provide the employee with their own scores, so they could at least say, well, you've given me sort of excellent appraisal marks for the last 5 years. How come when you've marked me on this, you've given me the lowest possible score for sort of contribution to the business in the selection matrix that many employers these days use. Move on, Callum. Anyway, that just gives you some more points about consulting with effective individuals, and just finally, a failure to consult can make it using the statutory procedure can make a dismissal unfair. Failure to consult if you're not using the statutory procedure, and in both instances, a failure to consult individuals can mean their own individual dismissal could be unfair. And the final point I'll just make is that even if there is consultation, a failure, to consult, that of course on its own is not sufficient to get a good win in an unfair dismissal, unfair selection of redundancy case. You will need more, because in particular in these sorts of cases, you've got Polky lurking in the wings. That meaning that basically, would it have made any difference? And I've mentioned right at the start, that's always haunted me, that case. And my client giving the answer, what would you have said in the consultation process? Well, I can't really think of anything I'd have said. And straight away, of course, in swooped Polky, and her compensation was limited to a month. And that's always something you need to think about in preparing the evidence for these cases. And I'll finish my part of the presentation there and move on to Paris, who's going to cover some of the other elements, special circumstances and protective awards.
All right, thank you, Nick. Good afternoon, everyone. My portion of this talk will focus on what happens if a tribunal finds that an employer has not complied with the collective consultation obligations. And specifically, as Nick has mentioned, I will be giving an overview of the special circumstances defence and the tribunal's discretionary power to make a protective award. So in terms of what section 1887 provides, it sets out the basis of the special circumstances defence and says, if there are special circumstances which render it impracticable for the employer to comply with their statutory obligations in full in respect of consultation, then it's sufficient to do as much as is reasonably practicable in the circumstances in question. What you'll see from the slide there is that there is a prohibition on relying on the special circumstances defence, where an assertion is made that the requirement for redundancies was taken by a controlling entity. In effect, this precludes an employer from arguing that the decision to make redundancies was effectively taken over its head by another party. The effect of this is that if an employer is told by its parent company or some other controlling entity that it has to implement redundancies, but not given enough information to comply with its statutory consultation obligations, even if the employer is not at fault, it will still be deemed to have been in breach of section 188, and the special circumstances defence won't apply, thus rendering that employer potentially liable for a protective award. Now, if you think about it, that's probably understandable, given that otherwise there would be a significant lacuna in the law in respect of the enforcement of these statutory consultation obligations. And finally, it should be noted that the burden of proof in raising the special circumstances defence is wholly on the employer. We turn to the next slide. The statutory provisions themselves provide no guidance on what amounts to a special circumstance. This has been left to the tribunals to determine on a case-by-case basis. What can be discerned more generally from the case law in this area has been that tribunals have adopted a restrictive approach to finding special circumstances where collective consultation obligations have not been adhered to. In my experience of conducting these sorts of cases, both in respect of claimants and respondents, I have seen tribunals give short shrift to arguments which centre wholly on the commercial pressures on employers who have to make collective redundancies. A problematic or even difficult trading environment on its own is not enough to make out a special circumstance. Whilst this can seem harsh, when you consider the fact that most employers will only be making collective redundancies due to commercial pressures, it's easy to understand why they of themselves can't amount to special circumstances. Indeed, the converse probably applies. Finally, just on the slide, the Collective Redundancies Directive doesn't actually expressly allow a special circumstances defence, unlike our domestic legislation. But the ECJ case law has supported this principle, and an example of that is seen in EC Commissions versus Portuguese Republic. If we turn to the next slide, there have, however, been a number of cases concerning insolvency and the applicability of the special circumstances defence. Notably, and of course of particular relevance to the current pandemic we face, where a winding up order has been made in respect of a business, that affects dismissals as of the date of the court order. And whilst technically it's the decision of the court that affects the dismissals, the employer is deemed to have dismissed the relevant employees. And this can also be seen in analogous proceedings, such as liquidation receivership cases, where a relevant insolvency practitioner effects dismissals. The duty to comply with collective consultation obligations still applies in principle because they're deemed dismissals by the employer. As mentioned, the interpretation of the special circumstances defence has been restricted, and this can be seen by the fact that even insolvency in of itself is not treated as a special circumstance, absolving an employer from complying with their consultation obligations. As we can see from the next slide, the courts have effectively differentiated between sudden insolvency and cases where a gradual deterioration in the financial position of the employer has occurred. In general terms, if an employer could see the way the wind was blowing, a tribunal may find that no special circumstances existed, whereas a sudden disaster precipitating terminal insolvency might constitute a special circumstance. There have been a number of cases which have distinguished between the two scenarios, such as Clarks v. Hove Limited versus Baker's Union, Usdaw versus Lean Cut Bacon, and G&B versus Rankin and Harrison. Each case is decided on its own particular facts, but where there is a dispute between the parties as to whether a particular insolvency situation was either a sudden disaster or a gradual deterioration or something in between, much like the test for unfair dismissal claims, the tribunal cannot substitute its own commercial judgment for the employer. What they can do is assess whether an employer genuinely and reasonably failed to foresee the insolvency situation. That is the focus of the inquiry. The next slide provides an example of a special circumstance being made out, but not the defense. In Keeping Kids Company versus Smith, the charity, which is Keeping Kids Company, had been facing financial difficulties and applied for funding from the government. In June 2015, as part of its application for funding, it had to set out a business plan, which involved significant redundancies effective to take place in September 2015 through a restructure. It was anticipated the charity would comply with its collective consultation obligations before the redundancies took effect in September 2015. In July 2015, the charity was informed that it was successful in its application for funding. Unfortunately, on the 30th of July, it was announced publicly that the police would be investigating the charity for various criminal allegations. As a result of this, the funding that was offered was withdrawn, leading to closure of the charity and the dismissal of over 200 employees. No collective consultation had occurred before those dismissals. Now at the EAT, Her Honour Judge Eadie accepted that the sudden withdrawal of funding did amount to an unexpected and sudden disaster, but that the special circumstances defence did not apply as it was reasonably practicable for the charity to commence consultation from the 12th of June 2015, when the application for funding was made, as it was predicated as a fixed, albeit provisional, intention for redundancies to take effect in September 2015. Turning to the next slide, an interesting case, an interesting point arose in this case, MSF versus Refuge Assurance PLC, concerning the requirement for secrecy constituting a special circumstance. In this case, an insurance company, namely Refuge Assurance PLC, was in the process of negotiating a merger with another insurance company. And the city's takeover code in force at that time precluded announcing any potential merger until it was made public. The merger involved redundancies if it went ahead, and one of the arguments raised by the employer was that it was unable to comply with its consultation obligations with the union on account of the secrecy demanded by the takeover code, which they asserted amounted to a special circumstance. Whilst the EAT didn't feel it necessary to decide that particular point, it did indicate, albeit obiter, that it was not persuaded by the argument, and it would have been possible to provide some information to a senior union officer on confidential terms to enable it to comply with its consultation obligations. The next slide looks at whether futility amounts to a special circumstance. And to answer it shortly, it doesn't. And that was confirmed in the case of Middlesbrough Borough Council versus TGWU. Remember, as Nick's mentioned, the purpose of the collective consultation obligations is to ensure consultation with a view to reaching an agreement, but not a particular outcome. Even if redundancies and job losses are inevitable, and consultation wouldn't change the end outcome, that does not absolve an employer from its obligation to engage in meaningful consultation. Furthermore, if you think about it, it's also potentially a dangerous argument for an employer to run, as it potentially means that an employer, even if it had complied with its collective consultation obligations, approached them with an entirely closed mind and effectively did a tick box exercise approaching a sham procedure, which of course is contrary to the underlying purpose of the consultation requirements, as touched upon by Nick earlier in this talk. The position in respect of futility in the context of collective consultation can be contrasted with that of individual consultation in a redundancy unfair dismissal claim, i.e. an individual claim, where of course futility of consultation might avoid a finding of unfair dismissal on a strictly procedural basis. And you'll have seen this case cropping up throughout this presentation. Mugford and Midland Bank is useful to read for that principle. Turning to the next slide, and this is just to re-emphasize the terms of section 1887. There are two requirements for the absolute defense of special circumstances to apply. Firstly, the existence of special circumstances, and then secondly, doing what is reasonably practicable in those circumstances. And in assessing what is reasonably practicable, the focus is not on whether an employer can show it was not at fault, but involves an objective assessment by the tribunal as to what was reasonably practicable for the employer to do, given the special circumstances which existed, in complying with the collective consultation obligations as far as possible. And examples of this was, as we've seen, in Keeping Kids Company and Smith, and also Hamish Armour. Assuming that the employer is unable to make out the special circumstances defence, we turn to the next slide. And that's remedies. As already touched upon, section 1892 makes clear that if a complaint is well-founded, the tribunal shall make a declaration and may make a protective award. The tribunal has a discretionary power to make a protective award, but a mandatory duty to make a declaration. And it should also be noted at this juncture that just because an employer has failed to comply with the collective consultation requirements, it does not necessarily follow that an individual claim for unfair dismissal will be successful under section 98 ERA 1996, nor is a claim doomed to failure if an employer has complied with collective consultation matters. The two regimes are effectively parallel or cumulative, but distinct. The next slide deals with locus to bring a protective award claim. And Margherita has already touched upon this during her talk, but to reiterate, section 1891 identifies 4 categories of potential claimants who can bring a claim for a protective award. And what you'll see there on the slide is A and D are the only claims that can potentially be advanced by an individual. So in respect of subsection A, where there is a failure relating to the election of employee representatives, any of the affected employees or any of those employees who have been dismissed as redundant can bring a claim. In the case of B, where a failure relates to employee representatives generally, i.e. they've been duly elected, it has to be the employee representative who brings a claim. In respect of C, where it's a failure relating to the representatives of a trade union, it's the trade union who brings that claim. And then finally, if A, B, and C do not apply, in any other case, an affected employee can bring a claim. So turning to the next slide, and I'll touch upon this very briefly, time limits. They're provided under section 1895, and effectively, you've got to bring a claim before the date on which the last of dismissals to which the complaint relates takes effect, particularly taking into account staggered redundancies, which large-scale redundancies generally take the form of. And in effect, what that position deals with is anticipatory dismissals. Now, generally, in my experience, those are quite rare, and they're particularly rare because of the backlog that the tribunals face in actually getting these claims to a hearing. So what tends to happen often is B is relied upon more usually, which is a period of 3 months, beginning with the date of the last dismissal. You'll all be familiar, those of you who practice in employment law, time limit's the same for unfair dismissal claims, effectively. And you'll also note from subsection C, in terms of extension of time, it's the stricter reasonable practicability test that governs extensions, and not the more generous just and equitable extensions, which primarily, of course, apply to discrimination claims. So some general points about the nature of protective awards on the next slide. Now, the primary purpose in making a protective award by a tribunal is to punish the employer for its failure to comply with its statutory consultation obligations. It is not to compensate the affected employees. It's a rare example of a punitive sanction within the employment law regime. And this purpose underlies the approach a tribunal should take in assessing its length, which is why the extent of any award is effectively linked to the blameworthiness of an employer, subject, of course, to a maximum cap of 90 days pay, or in rough terms, 13 weeks. The 90-day cap is the starting point in assessing a protective award, unless where there has been a complete failure to comply with the statutory consultation obligations, unless there are mitigating factors which lead a tribunal to reduce the award. The tribunal has a broad discretion in setting the protective award according to what is just and equitable. And the effect of this is that every case will be determined by its own circumstances. And of course, there is considerable scope for the tribunal to decide the level of award. Turning to the next slide. Section 1893 effectively allows a protective award to be made in two situations. Namely, as I mentioned earlier, those employees who have been dismissed or those employees whom it is proposed to dismiss. Again, in effect, anticipatory redundancies. Importantly, where there is a proposal to dismiss an employee, but at the time a tribunal makes a protective award and specifies a protected period, that employee is no longer proposed to be dismissed, that employee or employees cannot claim the benefit of any protective award. And that can be seen in the case of Securicor Omega Express versus GMB. It should also be noted that a representative claimant can only get a protective award for those whom she or he represents. So for example, a trade union advancing a claim can obtain an award for all employees in its bargaining unit, but it doesn't stretch to those which fall outside its bargaining unit. And that's irrespective of whether they are members of the union or not, and whether they are represented or not. And if you look at the case of TGWU versus Brower-Coley, and the dictum of Burton in that case, what he says is effectively, it's a case of each to its own. So an important caveat as to the ambit and scope of those who fall within a protective award. It therefore follows, of course, that an individual claimant, if they have standing, and we saw on the earlier slides, A and D categories may have individual claimants, they can only seek a protective award for themselves. And an example of that is seen as in independent insurance versus Aspinall. Turning to the next slide, in terms of determining the length of any protective award or protective period, guidance has been given in the case of Susie Radin on what features a tribunal may take into account when making and or setting the length of any protective award. And they include, in general, the fact that the purpose of an award is punitive. Secondly, the focus that a tribunal should have in setting the award is on the seriousness of the breach, which is, of course, a qualitative assessment. Thirdly, a consideration of whether any breach is of a technical or less serious nature or substantive nature. Fourthly, an assessment of whether any breach was deliberate by an employer. Fifthly, whether the employer had access to legal advice concerning its obligations to consult under Section 188. And finally, the proper approach is to start at the maximum period, i.e. 90 days, if there has been no consultation, and only reduce the award if there are mitigating circumstances. Turning to the next slide. After the decision in Susie Radin, there was effectively a widespread view that the general approach in assessing protective awards was to start at 90 days and reduce according to mitigating circumstances. And this was applied as a general rule by some tribunals and even representatives. And I mean, I recall when I was doing these cases shortly after Susie Radin, that was the argument I used to advance on behalf of unions. However, that approach misses the fact that the 90-day starting point only applies if there has been complete non-compliance with consultation obligations. Where there has been partial compliance, the starting point is actually at the discretion of the tribunal, and that can be seen in the decisions of Todd and Strain and London Borough of Barnet versus Unison. The approach was also seen more recently in Keeping Kids Company and Smith, where Her Honour Judge Eadie found that the ET had erred at first instance by failing to make any reduction to a 90-day protective award when full consultation would have proved impossible. And as you recall a few slides ago, that was potentially due to the sudden withdrawal of funding, which necessitated terminal insolvency. That leads us on to the next slide. Now, as seen in Keeping Kids Company and Smith, if an employer raises but fails to establish a special circumstances defence, which remember is an absolute defence, there may be factors within that failed defence which could be used to mitigate the length of any protective award. As seen, examples of this can be seen in Shanahan Engineering Unites and AEI Cables versus GMB. In effect, the employer gets two bites at the cherry. Once in respect of liability, i.e. establishing a complete defence, but again in respect of the quantum of any protective award. Another point to note is that where some consultation has occurred, the tribunal's focus should be on the quality of consultation, again a point picked up by Nick earlier, as opposed to the quantity. And an example of that can be seen in Unison versus Leicestershire County Council, and of course reference to that has been made in Susie Radin. A qualitative failure in respect of consultation is likely to be considered more serious than if it's a mere technical breach of the process. And where there's been a minor technical breach of Section 188, and in particular, this example applies to Section 188.4, this can be marked by a nominal protective award, as seen as Securicor, Omega Express, and GMB, because in that case, a one-day award was made for a failure to adhere to a provision of Section 188.4. However, protective awards can be very high value, as the next slide demonstrates. Now, Section 191 and 192 entitle employees to a week's pay for each week of the protected period, and pro rata for part of a week. So far, so pretty straightforward. Where things start to get expensive for respondents or employers is when you consider the week's pay is not capped per employee. The actual weekly pay of an individual is used, and to further bolster the value of such claims, the week's pay is calculated on a gross basis. So when you consider where there's a major redundancy process underway, which affects hundreds of employees, on salaries of say 30K plus, on average. Every extra day awarded under a protected award or protected period can be a very significant sum for an employer. And it's not uncommon for liabilities to exceed multi-million pound sums on a collective basis, especially where a 90-day award is made, which equates to 13 weeks' pay per affected employee. It's also important to note that protective award claims cannot be compromised by settlement agreements, but can be conciliated by ACAS via a COT 3. Just wait for the slides to catch up. Finally, moving on to the final slide, some of the exceptions for employees within a protected period are as follows. Firstly, where an employee is fairly dismissed for a reason other than redundancy, such as misconduct or capability, they cannot receive any protective award following dismissal where it falls within the protected period deemed by a tribunal. And that's usually the date of the first dismissals. A dismissal for a reason other than redundancy effectively acts as a novus actus interveniens and stops the protective award being paid to that employee. Section 1911A of the Act is the reference for that proposition. Secondly, an employee who resigns unreasonably equally loses the benefit of any protective award if it's during the protected period. And unreasonable is generally deemed to be without good reason. Relevant provision section 191B for that. Thirdly, an employee who unreasonably refuses an offer of further employment, either before or during the protected period, will also lose the benefit, either fully or partially, depending on when the refusal was, of any protected award. Finally, and somewhat morbidly, if an employee dies, any protected period is deemed to end on that date, i.e. the date of death, section 196. Thank you all for listening. We hope you found this talk interesting. If anyone would like our slides from this talk, please do get in touch. We're happy to answer any questions you may have in our Q&A session chaired by Callum. So over to you, Callum.
Thanks, Paras. I'm just collating the questions now, so bear with me 2 seconds. So there was a question, I'll ask you this one, Nick. We have to conduct staff representative elections. Can we do this with staff on furlough, as all staff are on furlough at present? Or can an elected staff representative carry out their staff representative duties while on furlough? You unmute yourself, Nick.
Interesting question. I would have thought, if you are carrying out redundancy consultations, then I can't see what, it'd be absurd if we couldn't involve the staff who are going to be made redundant. So my view would be, I've not something I've looked up, but my view would be that you would be able to, those staff would be able to have representation and involvement in the redundancy selection exercise, including providing representatives in it. I don't know what any of my fellow panelists think about that, but that would be my feeling.
I recall there was some guidance that furloughed employees, for the purposes of redundancy consultation, could be engaged to do that. Certainly, I think there's potential action taken by Unite against BA over that point, potentially. But certainly the government's guidance seems to suggest you can, subject to the decision of the court.
Thanks, Paras and Nick. Paras, this is a question for you. Would there be any scope to argue in respect of protective awards that the commercial circumstances were so dire that consultation couldn't take place? It's not a special circumstance, but that a protective award would exacerbate the problem such that more redundancies would be required?
Interesting question, interesting argument. I suspect a tribunal will make short shrift of that, but will analyse it, of course, on a case-by-case basis. You may recall, as part of my talk, I was talking about the tribunal ascertaining whether there was a gradual deterioration in the undertaking's financial performance versus a sudden event, which meant that it was impractical or not reasonably practicable or impossible even to comply with collective consultation obligations. The reality is financial pressures in of themselves, and even insolvency in of itself, does not obviously constitute a special circumstance, but may be a factor, going to the factors listed in Susie Radin, in mitigating the length of any protective award. But in effect, saying that we haven't complied, and if you make a whopping big collective protective award against us, we're going to have to make more redundancies, probably isn't going to be an attractive argument to run before a tribunal. Remember, the purpose of the award is punitive, so that's what the focus is on. Nick, I don't know if you have any other thoughts on that. A good question.
Just one further thing to add, and this can be aimed at you, Nick. So does the selection criteria need to be done after telling employees that their roles are at risk?
I would have thought the answer, especially in a statutory consultation, the answer would be yes, because one of the things that you would be consulting about would be the criteria to be used to select the staff to be selected. So, in fact, if you look at the turn to the relevant sections. Hang on. Right. I mean, my feeling was certainly that. Hang on, yeah. Yeah, the consultation, if you look at the information, section 108.4D, the proposed method of selection of the employees who must be dismissed is one of the actual things that has to be consulted on. So if you were to decide in advance how you were going to do it prior, before the consultation process, then quite clearly that would not be a consultation, because you'd already made up your mind. I think what the employer would be expected to do would be to put forward a suggestion as to how they intend and considering do it, carrying out the consultation to enable either the union or the elected representatives of the employees to have input into that process, and any suggestion that they'd already made up their mind prior to the start of the collective process would mean that the employer was at risk of having not been found to comply with their obligations to consult. So I would answer that question, yes, that you shouldn't decide how you're going to do it prior to the consultations taking place.
Just one final question for you, Nick. Can Lim B workers, for example, LLP members, contend that they should be collectively consulted with?
LLP partnership members. I think that would ultimately, it's going to come down to their status, I would have thought, if that means members of a partnership, whether or not they're also employees would be the issue there. If they're not employees, if they're just equity partners, I would have thought that they wouldn't be covered by the consultation requirements. That would be my feeling.
Okay, thanks, Nick. Are there any further questions or anything to add, Paris?
Just in relation to the Lim B worker question, it's a tricky question. I know, because there's been a recent decision on QP consultation, that Lim B workers were deemed to be within the scope of consultation requirements on that. To be honest, I haven't come across that in the context of a Section 188 claim, but I agree with Nick. I mean, if you look at Section 188, it talks about employees and dismissing more than 20 employees. If the member of the LLP or partner doesn't fall within the category of employee under Section 188, it's difficult for me at present and off the top of my head to see how they would fit in with that category. But it may be that some sort of analogous argument is able to be made by contrast to the 2P collective consultation obligations. But really interesting question, and something I'll ponder later today.
And Parash, just another one while Nick's looking that up. If we're making redundancies and we have a new role, can the employees at risk all apply for this role?
I don't see why not. There's effectively different types of redundancies. There's those where suitable alternative employment is chosen by the employer for a role and a trial period offered, which, if it's unreasonably refused, effectively affects compensation. But there's also a second type of redundancy situation where you can dismiss all and invite everyone to reapply for their new roles. Some of you who are following, as I say, the BA saga in relation to cabin crew will have probably noticed that their approach to this is to dismiss everyone and ask them to reapply for new posts. So depending on which way you decide to go, it's a matter for you whether you effectively interview everyone for the reduced posts or whether you offer suitable alternative employment to an employee. You really need to decide what sort of redundancy process you're running.
And Nick, another question for you. When the employees apply for the role, when the employees apply for the role, we have then carried out the interview process for the role. Am I correct that you can't just offer that new role to one staff member who you know is interested?
So, could you want to repeat that question again?
Yeah, when the employees apply for the role, we have then carry out the interview process for the role. Am I correct in thinking that you can't just offer that new role to one staff member who you know is interested?
Well, effectively circumventing the competition. In some ways, I think these are quite difficult questions, to address in a general sense. Some employers will, for example, when they make redundancies, they'll look at downsizing, for example, the size of a department. They will maybe look at the jobs which are left, and they will maybe look at the criteria. First of all, they may try and match people to the remaining roles based on basically their old jobs, being very similar to one of the jobs which is left, and have a job matching process. They may find that there's no one who's a sufficiently strong match to the new post, but there may be about 3 people who are near matches. Maybe 60% of their previous role is within the new role, and therefore they'll ring fence that post for those 3 people, and maybe they'll just allow a general competition if there isn't. In some workplaces. So the sort of factors involved in those sort of decisions, are the degree of specialisation needed for particular roles, whether there's any sort of job matching process has been carried out. I think that if simply employers offering jobs to people who are interested, I think there's all sorts of dangers for an employer going down that road. Not just in relation to claims of unfair dismissal, but clearly that sort of process or lack of process can also lead to arguments of discrimination of race, sex, or whatever for those employees who aren't the lucky ones who are deemed to have been interested. So I think any employer who is making redundancies, I think needs to think very carefully. If they have a duty to consult, clearly this is the sort of thing that we consider the selection procedures and how it will be done in the consultation process. But even where it doesn't involve and invoke the statutory procedures, need to think carefully how they'll do it fairly, because otherwise, it's not just the risk of the unfair dismissal claim, but other types of claim can be raised as well by employees who've not been successful in retaining employment with the company or organisation.
Thanks.
That answers that question. But
any further questions? Has anybody got anything else to add?
I did see one in the list. Do the information and consultation regulations have any relevance to this process? I would have thought generally the answer wouldn't be probably no, really. The statutory scheme for consultation of redundancies does provide very clearly the information required, and indeed the directive goes further, as I mentioned earlier, and requires the employer to provide all relevant information to the trade union or elected representatives, and relevant information, being about the redundancy process and measures and so on, and as we've seen in the list of 9 items which you find in section 1884, and so on, and so really it's that information which really a tribunal will be looking at, and I can't see any immediate impact of the information and consultation regulations on the information required in a redundancy process. The regulations which in my experience aren't used that much, I'd have to say, and I can't recall ever dealing with a claim involving them, which entitle workers in certain particular circumstances to information about their employer and to have agreements on the provision of information. But I think in these sorts of collective redundancy cases, I'd be more focusing on the obligations of the employer under section 1884 and under the directive rather than anywhere else.
Thanks, Nick. Well, if there are no further questions, thank you everyone for joining today's webinar. If anybody does think of any questions after the session is closed, please do not hesitate to contact either myself or Sam, and we'll ensure that they go to the speakers and we'll come back to you with answers. But anyway, yeah, thank you very much and goodbye.
Thank you. Bye.